Good afternoon and welcome to today's webinar, Carrying Out Caregiving, Checklist for Family Caregivers. My name is Juliana Valencia and I am a Social Services Specialist with Fairfax Area Agency on Aging. You should have received an email this morning with the speaker's slides for future reference. Today's presentation is being recorded and a recording will be sent to all of you by early next week. If you have any questions during today's presentation, just know that we will allocate 15 minutes at the end of the presentation for you to submit all your questions and concerns to our presenter today. Make sure you use your Q&A box, which is on your panel. In addition to that, there will be a brief survey as you signed out. Please take a moment to give us your feedback. It is really helpful because it helps us provide topics that you are interested in. Now it is my pleasure to introduce today's speaker, Sally Bolch-Hermy, who holds a Juris Doctor degree and has led the national conversation on many of the legal issues of concern to older adults, their families, their caregivers, whether the issue is how to make decisions for others or plan for what comes next. She is focused on explaining the law so that everyone can understand it. Her broad experience includes working with AARP for 23 years, teaching elder law at George Washington University Law School, and lecturing on how to get your legal house in order for great courses. Her most recent book on housing choices in later life, Wise Moves, is the 5th in the award-winning ABA AARP checklist series. Checklist for my family, checklist for family caregivers, checklist for family survivors, and get the most out of retirement. Sally is going to share her expertise with us today. Thank you, Sally, for being here and welcome.
Thank you. Glad to be with all of you.
Now you can go ahead and share your screen.
All right. All right. Can you see it now?
Yes.
Okay, very good. Well, I wanted to start out by thanking you for all that you do as a caregiver. I too am a caregiver, so I know that there are many things that we need to juggle as we take care of our loved one. And I also know that we have big responsibilities in making decisions for someone else. And so from my background as an elder law attorney, I wanted to go over some of the legal issues that you must understand as you are carrying out your caregiving responsibilities. Yes, I am the author of a number of books. Particularly wanted to talk to you about checklists for family caregivers. In this book, I have tips on how to make decisions for another, whether it's financial or healthcare related or any other kind of decision. I go over those legal responsibilities when you are making a decision for someone else, as well as explain many of the legal documents that you may need to decipher in your caregiving journey. As you might guess from the name checklist for family caregivers, I provide places for you to gather all of the information that you need to keep track of as you are making decisions and caring for someone else. One of the things that I found in talking with other caregivers that is really just a big problem is that many times just being a caregiver is not enough for you to have the legal authority to make decisions for someone else. And I'm going to go over some of those legal roles that give you the authority to make decisions legally. What I'll be talking about today is the different kinds of bank accounts and what this being a signatory on a bank account might mean. I'll talk about being an agent with financial powers in a power of attorney. I'll also touch on what it means to be a representative payee for a federal benefit. And I'll also go over what it means to be a guardian or a conservator in Virginia, a court-appointed role, and then talk about the issues involved in being a healthcare agent. We have lots of things to cover, and you'll find more detail about any of these in my book, Checklist for Family Caregivers. And if I raise some issue as I'm going through my presentation that you need more detail on or want me to explain in greater detail, I'll be glad to do so at the end of my presentation. So let's start with bank accounts. There are many different ways that you can create a bank account, and how that bank account is created can have big consequences, both for what access you might have for the money in that account, or what happens to that account after the owner of the account dies. So let's take one by one those various kinds of bank accounts that that your loved one might have or that you might need to create for your loved one. First of all, there's an individual account. Let's say my husband has his own checking account at the bank. It's in his name. I am not a signatory on that account. It's not my money. I can't touch it. And if he becomes unable to manage that money, that account is basically frozen, because he has said when he created that account legally that he's the only one who has access to that money and no one else can touch it. And as long as it's in an individual account, it's his money. We also have a joint bank account that at the time that we created it, I'm a signatory on it, he's a signatory on it. Because we both deposit money into that account, we both have access to the money in that account. We'll come back to that in just a moment. There's another kind of account that's called a pay on death account. Let's say your spouse creates, or your parent or anyone creates a pay on death account. The individual who creates that account, at the time they create it, they indicate to the bank that they have full access to that money. They're the only ones who can have access to that money, but automatically on the depositor's death, that money will automatically go to a named beneficiary. A pay on death account, I can, if you're the named beneficiary on a pay on death account, you do not have access to that money, you cannot touch it, but you will automatically get the money in that account upon the depositor's death. Probably the best kind of account in a caregiving relationship, let's say at least not a spouse, a child taking care of a parent taking an adult taking care of a sibling or someone else, is what's called an agency or a convenience account. The person who has authority can take money out of the account, can deposit money to the account. It's not their money, but they have legal access to use it. And this is probably the best kind of bank account for, let's say, a child who is assisting a parent in managing their bills and taking care of their banking situations. They must recognize that it's not their money, but they have access to use it to pay for the depositors' money. So let's say you are on a bank account with the person that you care for. It really depends on what kind of account it would be. You may have the right to access the money. You may not. Having joint bank accounts can create lots of family and financial issues. When it's a spouse, it probably, as long as there's domestic harmony, the two spouses have had a joint bank account, they've paid the bills jointly, they've put money in, they've taken money out, and they have used it as a combined fund. But sometimes when a joint bank account is created by a child and a parent, it can create situations that are ripe for abuse. Because with a joint account, not a convenience account, but with a joint with right of survivorship account, any person on that account can withdraw all of the money for any purpose that they wish. You can see that this might create some opportunities for abuse if the child does not really understand that they have a fiduciary responsibility to use that money if they've been made a joint owner, that they are still, it's not really their money to take a trip and go off to Reno and gamble it, or buy a car for their own purpose from the joint bank account with the parent. So there is a fiduciary duty in a joint bank account for the joint owner to recognize what they have. Although they have access to the whole pot of money, they really have to be careful how they use that money. Moving on from bank account, let's say there's a need to get access perhaps to that individually owned bank account or to any other kind of financial matter. And you probably think, well, I need a power of attorney, and that will give me the authority to take over because I don't like the way my spouse is spending money. I don't like the way my parent is spending money. They're making foolish decisions on how they're spending their money, or they're not spending their money, they're not paying their bills, they're not paying their utilities, whatever. Well, you can never get a power of attorney. It has to be freely and voluntarily given to you. So if you think you need a power of attorney for, let's say, the parent that you're a caregiver for, they need to understand, they need to have the capacity to understand what they are doing in creating a power of attorney and who they want to give legal authority to. We all understand the capacity to make the decision to give someone a power of attorney can fluctuate. There can be good days, there can be bad days, but it has to be a good day to create a power, to give a power of attorney to someone else. So let's say you are the agent under a financial power of attorney. This does not give you carte blanche to do whatever you want to do. You must follow the directions that are given in the power of attorney. The person creating the power of attorney can say, you can do this, you can do that, this is how you're supposed to do this, this is what I want you to do, this is what I don't want you to do. Whatever those directions are in the power of attorney, you have the responsibility to follow those directions. And you carry out the decisions as an agent with a power of attorney in the same way that the individual would have if they, let's say, could make that decision at this time. So again, let's go back to that situation where you are the power of attorney for your parent. The parent says, I never want to sell my house. I never want to go into a nursing home. You as an agent must follow those directions. Just because you're an agent doesn't mean you can do something that the person, the person does not want you to do. So even though you are an agent with a power of attorney, you cannot sell the house if you know that they don't want you to sell the house. Excuse me, I have seasonal allergies, as many of you might understand. You need to keep good records of the decisions that you make and how you spend your money. You need to recognize that as an agent, it is not your money, it is not your resource, it is not your house, it is not yours. You are carrying out what they told you to do, whether they still have capacity or they don't. Another way that you can get legal authority to serve as to take charge of some money is to become a representative payee or a federal fiduciary. This is an administrative process either through the Social Security Administration or the Veterans Administration. If your loved one is receiving retirement income or disability income, and they are having difficulty managing that benefit, you can apply to Social Security or Veterans Administration. It's basically the same process. It's an administrative process. It doesn't go through the courts. And you would have an interview and you would explain why there is a need for your loved one to have assistance in managing their benefit. You will need a medical letter from a doctor or physician saying this individual has difficulty managing their money for one reason or another. And if you're assigned as representative payee, you will then receive that benefit check. But your authority will only be on that particular benefit. It does not give you authority over any other bank accounts or anything else. The benefit check that comes to you must be deposited in a separate special bank account that lists the beneficiary on the account as the owner of the account, but you have the authority to spend that money. According to Social Security regulations, you can only use that money for basic necessities, food, clothing, and shelter. Remember, it is not your money. It is money that you have access to use on behalf of the beneficiary, and you must report to Social Security on an annual basis as to what money you've received and how you have spent that money. It's interesting to note, at least according to Social Security, being a spouse is not enough to give you authority to spend someone else's Social Security benefit if they're not able to manage it themselves. I know that this is not enforced, but technically, legally, according to Social Security regulations, I'm telling you that if your spouse needs assistance managing their Social Security benefit, you should apply to be a representative payee. But I've told you what you should do. Also, let's say you're not a spouse, but you're on a joint bank account with the beneficiary, and that Social Security check is being deposited into a joint account, which you have access to. Well, being the joint owner on the bank account where the Social Security check is deposited is not enough, according to the Social Security Administration. That you, if you want to manage that Social Security benefit, need to apply to be a representative payee. If you are appointed as representative payee, you can only spend that account on necessities. You must keep records of how you spend your money, and you must account on an annual basis to Social Security. It's a very basic form, and it's just a summary, sort of one-page thing. I got this much money in Social Security, and I spent this much money on food, clothing, and shelter. But it is a way for you to help, as a caregiver, someone manage their Social Security benefit. The very last resort, if you need to take over the decision-making responsibilities for someone who is seriously incapacitated, you may need to go through the court process to be appointed as a guardian. Guardianship is a serious deprivation of civil rights and decision-making rights, but it can be very appropriate if nothing else is working, or if the power of attorney for some reason or another doesn't cover decisions that need to be made, or there's no other way for important decisions to be made for that individual. What is guardianship? It is a court process in which you need to petition the court. You need to identify what decision-making inabilities the individual has. You need medical evidence of what they can and cannot do. What diagnosis do they have that makes it difficult or impossible for them to protect their own personal health or financial safety. There would be a hearing at which evidence will be presented to the court, witnesses, documentation, testimony. The individual has the opportunity to appear and testify. They will have in Virginia, they will have legal representation, either of their own choice or appointed by the court. There will be a guardian ad litem appointed by the court who will interview the individual and the proposed guardian and examine the documents to make a recommendation to the court as to whether guardianship is necessary and whether the proposed person to be guardian is the appropriate person who can carry out their responsibilities as a court-appointed guardian. The guardianship process can be very costly emotionally. There can be disagreements as to within the family as to who should be appointed. It can be embarrassing to the family and to the individual to need to go into court to have, documentation and testimony about the problems that this individual is having taking care of themselves. And it can be costly financially, unfortunately. The medical examination, your lawyer as the petitioner, the lawyer for the individual, we call them the respondent, who is subject to the petition, the cost of the evaluation and the review by the guardian ad litem, all are costly. All those lawyers have to get paid. But what happens through guardianship is that it creates a court supervised decision maker. And that decision maker in Virginia they have they've bifurcated the two parts of guardianship. There can be a guardianship of the person who has responsibility for personal decisions, or a conservator of the property who would have responsibility for managing the financial assets of that individual. So let's say you have been appointed as guardian or conservator for your loved one. If the court determines that there is a need for a guardian or a conservator, and that you are the appropriate person to be appointed as guardian or conservator, and you can be appointed, one person can serve as both, but they're two separate appointments. You will get letters of guardianship from the court, and this will be the legal document that you will use as you are dealing with other decision makers, whether it is a doctor or the hospital or a landlord or a banker or a stockbroker or a whomever, that the letters of guardianship are it's the piece of paper that give you the authority to make decisions on behalf of the other individual. But even though most guardians and conservators have extensive authority, there certainly are certain things that you cannot do. As a court-appointed guardian or conservator, you have fiduciary responsibilities, which means that you must very carefully manage the money. You must carefully and wisely invest any money that you are responsible for. You must promptly pay all legal bills as they come due. You must make financial decisions if you're a conservator, or personal decisions as a guardian in the best interest of the individual. You need to know what you can and cannot do. The Virginia Code sets out some limits to the extent of your authority, as well as certain actions that you may need to go back to court to get specific authority ahead of time to make those decisions. But even though you are now guardian or conservator, you are not all-knowing, and you are not you're not God. You still must make decisions that are in the individual's best interest. You should strive to make decisions that the individual would make if they could, and include them in as many decisions as possible. You want them to feel like you are working with them, not working against them in making arbitrary decisions. You are responsible for making sure that they are being well cared for, that their money is being well managed, that they are getting the services, the education, the rehabilitation, the medications, the medical treatment that is the very best for them. As either guardian or conservator, you must annually report to the court. You must keep very detailed records, bank statements, receipts, all the documentation that you need to present to the court to show how you have respectfully and responsibly made medical decisions, placement decisions, whether they're being properly cared for in assisted living or a nursing facility. You must be able to show to the court the important decisions that you made, why you made those decisions, and why they're in the best interest of the individual, as well as what money you have received, what money you have spent, and how you have invested and managed that money wisely. Most of what I've been talking about so far have primarily dealt with the financial issues and getting the legal authority to make financial decisions, whether it's as the joint owner on a bank account or as representative payee or as conservator for the individual. But now I would like to turn to more of the healthcare issues. True, a guardian of the person is making healthcare decisions, can make healthcare decisions, but outside of guardianship, before guardianship, it's important to understand how you can get authority to make medical decisions for your loved one. And that legal authority comes through a document that we call advance directives. There are really two parts to an advance directive. You've probably heard about a living will. And a living will is a statement, a declaration of what the individual wishes for end of life treatment preferences. A living will is truly an important document to have, but it has some limitations. It only speaks to end of life decisions and those life-sustaining or life-supporting treatments that are involved, such as intubation, cardiopulmonary resuscitation, and those treatments that can possibly extend life. Because there are many medical, and the other sort of problem with a living will is it's just a piece of paper. It's a very important piece of paper for end-of-life treatment preferences. So someone knows whether they do or do not want life-sustaining treatment. Recognizing that the living will or end-of-life declaration provisions are really limited in scope, it's important to have sort of the second part of an advance directive. And that is the selection of a spokesperson, your agent, your healthcare agent, the individual who will have the authority, the legal authority through this document to make those decisions on your behalf. And in that second part of an advance directive, you can give your agent the authority to make any treatment decision, not just limited to end-of-life treatment preferences. You can talk about exploratory surgery, antibiotic treatment, cancer treatment, use of antibiotics, whatever, far beyond end-of-life treatment preferences. So let's say you are a healthcare agent. Keep in mind that your loved one, even though you are the healthcare agent, your loved one will make the decision whenever they can. And it's only after a physician has determined that they are not capable of making that specific decision do you step in to carry out your loved one's decision that they have previously made. This means that your authority as a healthcare agent can come and go. If they can make the decision, they make the decision. If they cannot make the decision, then you are there to make the decision on their behalf. Again, as a healthcare agent, you are standing in their shoes, so to speak, to make sure that their wishes are carried out. It is not your decision to make. You are just making sure that your loved one's decision is being honored. Just like with a financial power of attorney, you must follow the directions in the directive. So if they say they want X and you wouldn't want it for yourself, it doesn't make any difference. You are there to make sure that X happens. It's not the decision you would make, but you need to think of yourself as a healthcare agent as the eyes and ears and mouth of the patient. You can get information, you can talk to the doctors, you can make that analysis of the risk and benefits of any proposed treatment, and then you say, I am speaking on behalf of my loved one. This is the decision. This is the consent to do X, Y, or Z, whatever the healthcare professional might be recommending. And you, again, it's so important to think of your role as being the eyes to see how the patient is getting along, what the doctors are recommending, to hear what is being said, and then to enforce and honor the patient's wishes that they have given you the authority to make in the advance directive that they've prepared in advance. So this is definitely, in a nutshell, covering a whole lot of different issues. What I have here are a number of resources that I think you will find very helpful. AARP, where I used to work, and I probably wrote some of the stuff on the Caregiving Resource Center when I was still at AARP, has lots of good information and resources and articles and tips and ways to make caregiving, all parts of caregiving, easier for you. The American Bar Association has an excellent advanced healthcare planning packet with that goes in greater detail about how one to prepare an advance directive, what to think about, what to put into your directive, as well as helpful information for the agent to understand what it means to be a healthcare agent. The Consumer Financial Protection Bureau has a number of guides called Managing Other People's Money, and they're on being a conservator, on being a representative payee, on being a financial agent, and they are very plain language, easy to understand, that sets out exactly what your responsibilities are when you do have the authority to manage someone else's money. And then the National Guardianship Association, of which I am a member, has created Fundamentals of Guardianship, which is a desk reference really on how to be a guardian or a conservator explaining the steps that you need to take to make as you make decisions for someone else. And they've also created standards of practice, which is sets out the ethical guidelines for serving as a guardian or a conservator. And again, here is the list of the books that I have written. They're all available on Amazon or through Barnes & Noble bookstores. Checklist for Family Caregivers, Wise Moves, Checklist for My Family, Checklist for Family Survivors, and Getting the Most Out of Retirement. So I am going to stop showing my screen. Here's a copy of Checklist for Family Caregivers, just so you can see what it looks like. And now I would be delighted to answer any questions. If you can, I'm not, feed them to me, read them to me, tell me what they are. I'd be glad to answer any other questions.
Thank you so much, Sally. And you explained it so well. This is actually the first time that it is very clear to me what's the difference between living will and a power of attorney. So thank you so much for making it, for giving us these explanations that are very easy to understand. So I will, we do have a few questions from the audience. Please feel free to submit your questions. So I have, the first question says, I am my neighbor's POA. She is currently 97 years old, but is having memory problems and can no longer handle her own financial affairs. She has no family in the area, only distant relatives who are not involved in her life. I'm currently assisting in paying bills, paying for home care, etc. She still feebly manages to sign the checks. Should she become no longer mentally capable of understanding her affairs, the POA gives me broad powers, but denies the POA access to her trust. My concern is that when she created the POA, she placed her home and checking account in the trust, and the POA authority does not give me the authority to access her checking account, nor do I have the authority to sell her home should she have to go into assisted living. I find I am kind of in limbo land. Should she get to the point of no return, since the checking account and home cannot be accessed by me to take care of her financial matters, her financial matters, the bank manages her, sorry, I went all the way to the top. The bank manages her trust and is also the trustee. Should I be concerned?
Oh, what you need to do is to establish a good working relationship with the bank. And it's unfortunate that it is the bank, because sometimes they're not as personable as you might like for them to be. But because she does have put her house and the bank, and her bank account in the trust, it's the trustee who has that authority, and she has made that division. Bless you for the work that you are doing now in taking care of her. So important that she has you when she doesn't have a nearby family. My heartfelt advice is start talking to the trustee. Make sure that the trustee at the bank understands the wonderful work that you are doing and your concerns as her health is declining and her needs for her potential need for additional care, which can only be paid for by selling the house and getting skilled care in a facility. Or maybe she can, with home health care, stay in her home until the end of her life, which may be a wonderful thing to do, but you don't have access to the resources. As I understand it, the trustee is the one who is going to have to appreciate your caregiving concerns for her. Reach out to that trustee, reach out to that trustee and explain what your concerns are for need to access resources to make sure that she is getting the care that she needs, either in her home or in a skilled facility. Reach out to that trustee. Hope, my fingers are crossed that it's a good one.
Yes, yes. So I have another question here from one of the audience, and it says, for whatever reason, I'm not able to read it completely, but it says, let me see. In the meantime, while I'm trying to navigate that, let me read this question. Virginia is a nearest in blood or next of kin type of state. Why do I need to have a medical advance directive or a power of medical power of attorney if I already know what my mom wants?
Okay, yes. If your mother does not have an advance directive, as she has not given you or anyone else the specific authority and direction to make decisions, Virginia does have what we call the family consent law. And that gives direction to the hospital or the medical professional, a priority list of who to look to make a decision. So what your mother is doing is relying on the doctor to be willing to comply with the Virginia statute that you, as the next of kin, will be the decision maker that will be the decision maker for your mother, as long as you are the statutory next of kin. If you have if you're an only child, that makes it clear. If she is a widow, that makes it clear that you would be the next of kin. If there are, we've got to go through sort of the determination of who and the definition of next of kin. If you have siblings, they also would share the decision-making authority with you under the Virginia law. So your mother can trust the hospital and the doctor to look to you to make that decision. If I were your mother, I would want to just go through that important process to clarify any issues, that you are the person, regardless of who else might be in the family, regardless of who else might be interested in sticking their nose into your mom's business. It makes it more legally crisp and clean. But yes, without it, if you are the next of kin, the only person in the statutory priority list to make decisions, yes, the doctor will look to you. So, but if she doesn't want to give you healthcare powers, then she doesn't have to. You can rest assured that you will be the person. But she's relying on a statute instead of a piece of paper.
Okay, thank you. So we have another question from the audience, and it says, it's kind of related to the one I asked you before. Without an advance medical directive or power of attorney, can a spouse legally make healthcare decisions for their partner?
Yes, under that same statute, the Virginia Family Consent Statute, the spouse is the first person listed in the statute as having, as the person to whom the healthcare provider can look to make a consent or a decision on behalf of someone who does not otherwise have an advance directive or a guardian or conservator.
Okay. Our next question says, do you have to have guardianship before claiming parents as dependent on your income taxes?
Nope. As long as you, that has to do with IRS rules, tax rules. As long as you are providing more than 50% of all of the living expenses, you can claim a parent, a disabled, incapacitated parent, as a dependent on your income tax. Has nothing to do with guardianship. It only has to do with IRS rules.
Okay.
Talk to your tax accountant.
Okay. Really good to know that.
I'm not one.
Okay, great. So the next question says, being a caregiver of a 38-year-old son with disabilities who is not capable of taking care of his financial needs and needs daily supervision and guidance, can guardianship be set up with specific parameters that fit his unique situation? He is childlike but can take care of some of his needs, but needs protection as he could make and be coerced into making some very bad decisions. He would not understand what he was doing.
Okay, yes, absolutely. And that's what we call limited guardianship or limited conservatorship in Virginia. And this is the very best way to go in circumstances like this. And what you would want to do is to petition the court for only specific powers, such as that would give him the ability to manage, let's say, his own wages or his own spending, small amounts of spending money, but that you would have authority over larger financial decisions. It would give him, you would not have the authority to determine, let's say, where he lives or who he associates with or what work he has, but you would only ask for the court for the specific areas in which he needs assistance or supervision. And do not go for full guardianship or full conservatorship, but work with an attorney to identify just those maybe one or two major protections that you think are important to keep in place, but to still give him as much independence and authority and self-autonomy as he possibly can. Very good question.
Thank you. Thank you. So my next question says, my mother is a representative payee for my father. A few years ago, the SSA informed her that she's no longer needed to report on how his Social Security check is spent. The money goes into an account on which I am joined with my parents. I haven't made withdrawals from the account, but my mother does use it for lots of reasons that aren't necessities. Should there be another account for that?
Yes. Yes. That Social Security check should go into an account in your mother's, well, in your father's name with your mother as the representative payee, as the agent on that account. And there should be no one else should be on that account besides the representative payee. So what do you need to do? I guess, I think I heard the question saying that your mom is using the funds in the Social Security account for things that are not necessities.
That's correct.
That's not the way it's supposed to work. She needs to, you need to counsel your mother that she can get in trouble with Social Security, and she can be personally, financially responsible even as a spouse, for monies that she misspent um, um, of that Social Security benefit. So talk with your mom about creating the account that is important. This is why Social Security is supposed to be keeping. I know there is what I consider to be kind of an unfortunate law a couple of years ago that said that family members who were representative payees didn't have to account as much because they considered it a burden. But this is exactly why there should be that accounting and not that exception, but that's the law right now. So yes, you do have a problem. It's not the way it's supposed to work, and she's not following her responsibilities on that account. So good luck. Social Security doesn't want to hear this. I don't want to hear it.
That's true. So our next question, we still have a few more minutes. It says the slide about representative payee says it should go into a special account. Is that true even when it is currently going into a joint account? And I think you kind of answered that question.
Right. Yes, it should not be going into a joint account. It should be going into a Social Security beneficiary account.
Okay. So our next question says, I am 62 years old and care for my 91-year-old mother. I have POA and I am her healthcare agent. She is of sound mind and I am her only relative, and we have no one to take care of her should something happen to me and my husband. He's backup POA. She has a revocable living trust and I am her trustee. How can I plan for her care if something happens to me and my husband? Would it be a guardianship? Does the trust that she has help with that from a legal standpoint?
Okay. The trust would be separate from the guardianship because that is property that she has designated with a decision maker who is the trustee. That's you. There's sort of two separate pots of assets and resources with different legal titles, because the assets in the trust belong to the trust, don't belong to her. There needs to be a success in the trust. The way it should be drafted and set up is that there should be a successor trustee, just as your husband is the successor agent on the financial power of attorney. At least there's a second person. I don't know if on the trust there is a successor trustee. A good thing to do, I'm not going to call it better or anything like that, but a good thing to do would be to amend the trust to name a successor trustee who would only step in, as you say, in the event of your you no longer can be able to serve as the trustee. On the financial power of attorney, again, it would be good. It's good that there's your husband is the successor trustee, but is there someone else who could be the successor to the successor if you're concerned? You don't want to, since you do have power of attorney and there is the trust, those are the advanced planning tools that we look to avoid the need for guardianship. But that is kind of a sticky thing. I would not want to see if you can think of someone else who could be the successor trustee and or the successor outside of the, you and your husband on the power of attorney, that would be much wiser, less expensive, less complicated. Don't think of guardianship as the solution to this problem if you can find any other way to avoid getting guardianship or conservatorship.
Sorry, my mic was muted. Thank you so much for those insightful answers. We have a list of questions. Unfortunately, we ran out of time and we are no longer able to get to those questions, but I wonder if I can email them to you and perhaps you can address some of those questions, and we'll make sure you in the audience get the answer to those questions. I don't know if that's too much to ask,
No.
Sally?
Be delighted to answer. These have been wonderful questions, very, very thoughtful questions. So any questions that anyone has that I've not been able to reach, please do just send them to me by email whenever you can put them together. And I'll be glad to see what I can do to get some answers back to you. And then you can take care of getting them back to the people who've asked the question.
Thank you so much, Sally. So we are getting ready to end, and as you signed out, there will be a brief survey. Please take a moment to answer those questions and help us provide topics that you are interested in. Sally, thank you so much for the valuable and insightful information that you presented today. Thank you so much for sharing your time with us, your expertise. It's been really, really valuable for us. Thank you. Also, thank you to everyone in the audience for joining us, for taking time of their busy schedules to be here. And thank you for submitting your questions. And everyone, have a great afternoon. Bye now.